A federal court has just struck down this gun law. And wait till the end of the video when we get to what is going to make your blood boil that the prosecutors argued in court for why the law should be constitutional. Before we get there, my name is Tom Grieve. I'm a former state prosecutor, criminal defense attorney, and as a quick reminder, the USCCA has a secret giveaway going on right now that ends soon. It's free to enter. Just click on the link in the description below to reveal what it is. So the case that we're talking about is US v. Harrison, which comes from the Western District Court of Oklahoma. The law that we're talking about is 18 U.S.C. 922 sub G sub 3. For those of you who do not commit federal statutes to memory, which largely includes myself, we're talking about the ban on individuals who are users of cannabis or marijuana from being able to possess firearms. For those of you who may not be aware, there's been a bit of a wave across the United States when it comes to the legalization of THC. We're going to be getting into that in just a moment, but what arguments are we talking about here? There's going to be three things that we're going to see covered in this case. Who's a law-abiding citizen under the Bruin test? Who bears the burden of proof? So the burden shifting analysis. Does the individual, the defendant in court, have to show that the law falls outside the historical tradition, or does the government need to show that? And then lastly, and most egregiously, and you got to stick around for this, we're going to be dealing with the folks who the government says are presumptively risky individuals, their wording, not mine, and whether or not that should extend to the unvirtuous, their wording, not mine, folks who use THC. So we're getting to all that and more, and again, you got to stick around to hear what's going to make your blood boil, because it made my blood boil, and I really don't say that very often. We're going to talk about the facts of the case. Basically, there's a traffic stop because Mr. Harrison blew a red light on his way to his job at a medical dispensary. A backup officer was summoned to the scene. There was a search of the car. There was a loaded revolver found on the driver's side floorboard, as well as a number of pills, as well as, of course, cannabis, marijuana, THC, and it came in all sorts of different forms: gummies, vapes, THC, cigarettes, and stems. Mr. Harrison faces criminal charges out of Oklahoma, so the state criminal court, for the possession of THC as well as paraphernalia, in addition to the traffic ordinance violation for failure to obey a traffic signal. That's the red light violation. And I will note that it seems like he was not in possession of the state-issued medical marijuana card. However, on August 17th of 2022, he was later indicted by a federal grand jury for being in possession of a firearm with knowledge that he was an unlawful user of marijuana. Again, going back to the federal law and the fact that under federal law, this is all illegal. I'm not going to read you the whole statute. If you want to see that, check it out in the description box below. Also, if you want to see a whole much longer detailed analysis of everything here, be sure to check it out on my channel. Just Google Attorney Tom Grieve. You'll find it there. I want to make sure that this is going to be a quick hits one for those of you who may not have 25 minutes, but this is going to cover everything that you need to know. So you're going to be going through different definitions in there, but again, I want to catch you up to the fact that medical cannabis is now lawful in 37 states. 37. Recreational marijuana is now lawful in 21 states. An additional 10 states have decriminalized the use of marijuana to varying degrees. Now, it's easier for me to name the 11 states where it is actually still a crime, namely Wisconsin, Idaho, Wyoming, Nebraska, Texas, Indiana, Kentucky, Tennessee, South Carolina, and Georgia. I want to give an important legal disclaimer for not only myself, but also for the United States Concealed Carry Association that, look, before you go out and possess marijuana, regardless of whether or not you have a firearm, please, please, please check your local listings. The ability to understand and research things for yourself is one of the few things we have left in this world. Don't outsource it 100% to the internet. Make sure that you check your local listings to see what the laws are with your place and time. I don't know if you're watching this video soon or in the year 2050 or something like that. Hopefully not. But of course, this remains illegal under federal law. So that's really kind of the big issue here that we're going to be dealing with. All right. So in court, Harrison argued in the federal court that, and he says, look, this is not part of the nation's historical tradition. In other words, banning users of a Schedule 1 through 5, which is technically what the law does, is if you're an unlawful user of any controlled substance. So whether that's a Schedule 5 codeine-laced cough syrup, or whether it's a Schedule 1 cannabis, methamphetamine, heroin, you name it, doesn't matter if you're an unlawful user of or addicted to, no go. The government basically says a handful of things. Number one, they say that Harrison is actually not a law-abiding citizen, and therefore he is not protected by the Second Amendment. Number two, they're saying that, look, we don't bear the burden of proof on this. Harrison is the one that bears the burden of proof on this. In other words, Harrison's the one that has to show that it does not fall inside the historical tradition of the country. The government also argues that, look, there's a tradition of keeping presumptively risky people, like felons and mentally ill, from possession, and that should extend to THC because those folks are unvirtuous. Again, their wording, not mine. And again, stay tuned for the blood boil part. Okay, this law basically comes to us from the Gun Control Act. It went under a number of revisions, most notably in 1986, to broadly prohibit the receipt or possession of a firearm from anybody who is an unlawful user of or addicted to any controlled substance. So that's where it comes from, fundamentally the 1968 Gun Control Act. As a reminder, here's the test that Bruin has given us. I'm going to read it basically from Bruin. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. That's straight from New York Rifle State Pistol Association v. Bruin, which of course came out in June of 2022, and is really the case now to explain how courts are meant to analyze and interpret Second Amendment regulations and statutes. So, a quick reading of Bruin, there's two things that immediately become evident. Number one, an individual who is possessing a firearm and going armed, particularly a revolver, that's going to absolutely be considered to be constitutional conduct. And this isn't even open for debate. They basically said that verbatim, the U.S. Supreme Court did in their decision. Number two, also verbatim from the decision, is the fact that it's the government who bears the burden of proof here. So Harrison does not need to demonstrate that, look, 922 sub G sub 3, this falls outside the historical tradition. It's the government who bears the burden of proof to show that it falls inside the historical tradition. And how, frankly, a prosecutor could read Bruin and reach the opposite conclusion, I'll never know, but unfortunately, I'm also equally as unsurprised, all right? So the court says that, look, we are talking about the people when we're talking about the Second Amendment, and you cannot create carve-outs for different groups of individuals beyond a few canonical categories. Again, felons, mentally ill, so forth, okay? But at the end of the day, the court goes through a lengthy analysis and concludes that, look, the people are absolutely protected. This is actually protected conduct, i.e. carrying the revolver while going armed. Therefore, since we cannot create carve-outs under the Second Amendment, no. Mr. Harrison is not exempted from protection under the Second Amendment. So the next thing that the government gets to is they argue that there's actually 7 historical laws that they believe are directly analogous to 922 sub G sub 3. And therefore, look, 922 sub G sub 3 falls inside the nation's historical tradition. I think those laws basically fall into 3 different categories. Number 1, individuals who are intoxicated. Number 2, folks who've been convicted of a felony. And number 3, people who are mentally ill. I'm going to briefly cover each one of these. If you want, again, the longer analysis, check out the video on my channel. But briefly, what the government said here is, look, they've cited laws going back to actually 1655 dealing with this, and the court says no. No, because the intoxicated possession and the intoxicated laws in general, we're dealing with the fact that you actually have to be intoxicated. It's not like if you have a drink on Saturday, you're not allowed to possess all week, which is in essence what 922 sub G sub 3 does. You're not basically stripping the whole Second Amendment because someone occasionally drinks alcohol, which is exactly what it would need to be in order to be analogous and therefore have 922 sub G sub 3 fall inside the nation's historical tradition. In other words, these are 2 completely different things. The court also does a further breakdown analysis of all the other laws to go through why each of the 7 absolutely does not put 922 sub G sub 3 inside the nation's historical tradition. So the court throws that out as well. And I'm going to read a great quote from the court here where it says that where the 7 laws the United States identifies took a scalpel to the right of armed self-defense, narrowly carving out exceptions but leaving most of the right in place, 922 sub G sub 3 takes a sledgehammer to the right. So we get briefly to the description of felons, where the court basically draws a distinction between the fact that on the one hand, the law prohibiting individuals who are felons from possessing, which the Supreme Court said basically this is going to be largely good to go and falls inside our tradition. So the government here is trying to say, look, we prohibit felons, we prohibit people who are presumptively risky, therefore this should also be the same thing. It's directly analogous, which means 922 sub G sub 3 falls inside the historical tradition. The court says, not so fast, and here's why. They draw an important distinction between somebody who engaged in felonious conduct, was caught, investigated, arrested, charged, had an attorney, went through due process rights, had the right to a jury trial, was convicted. That is an entirely different fact pattern from somebody who was allegedly engaging in conduct that may or may not be a crime, depending upon which state you're in. Again, federal law is federal law. But as a result, with, in essence, no due process rights, you've now been stripped of a constitutional right of your Second Amendment. These are not analogous laws, and therefore, the prohibition against felons and this law, 922 sub G sub 3, they are not directly analogous. Next, the government turns to, and again, we're going to get to the part that's going to make your blood boil in a moment, so stick with me here. We're going to get to the fact that the government's citing to individuals who are mentally ill. And the government cited to a number of different laws, and I'm going to use their wording, not mine, where they basically pointed out that most of these laws deal with people who are quote-unquote dangerous lunatics. Their wording, not mine. Keep in mind, a lot of these laws are quite old. So basically, the court analogizes and looks to the fact of, look, virtually all these laws that deal with historically, not maybe modern laws, but historical mentally ill laws, which leads to the deprivation of 2A rights, we're dealing with people who have a propensity towards violence. And the court points out that the almost 400,000 Oklahomans who use marijuana under the state law authorization, how are these people dangerous lunatics? And in the court's view, this is a bridge too far. Great movie, by the way. But this is a bridge too far and says, look, this is not directly analogous. If you stayed with me so far, congratulations, because now you get to see the type of arguments that you are going to get to suffer through for maybe a decade plus. Next, the government really goes into the garbage bin of history. And they say, look, you know what else is part of our historical tradition? How about those laws that prohibited slaves, freed slaves, Native Americans, Catholics, and Loyalists from being armed, stretching back to the 17th century? Right. That's how desperate the government is. And USCCA, we told you about this. We went all the way back and analyzed the Bruin decision that, look, this was going to be coming up, and here we are. So importantly, a couple things. Number one, there's been going back to 1871, there's been a case law tradition in the United States where we have said, and by that I mean the U.S. Supreme Court has said, that the First and Second Amendments in particular recognize pre-existing rights. In other words, they're not rights that are created by the First or Second Amendment. These are rights that actually come to us before the Second Amendment. So in other words, before the Constitution, before everything. These are innate, inalienable human rights. So that's one thing we've got to keep in mind. The second thing is, and it's cited right in the Bruin decision, is the fact that, look, when it comes to interpreting the Constitution, not all history is created equal. In other words, don't come to us talking about laws prohibiting Catholics, African Americans, or Native Americans and Loyalists, and basically dispossessing them of any constitutional right as now being valid for why we should be able to strip them their free speech or Fourth Amendment, whatever it is that we're talking about right now. No good. Thanks for trying. All right. Guys, I hope you enjoyed this video. Again, the longer form analysis you can find on my channel. Just look up Tom Grieve. Please show your support for the USCCA, though. Absolutely fantastic organization that I'm proud to have been involved with to varying degrees for going back 8 years at this point, which is hard to believe. Show your support by clicking subscribe on this channel. Click like in this video. Share it around. Let us know in the comment section below. What do you think is going to happen with this? Is this going to be appealed? What do you think are the government's strengths and weaknesses? And again, where do you think this is going? Let us know in the comment section below. Thanks for sticking around this long.